First District Court of Appeals, now in session. All who have business before this court draw near, give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. We have two cases on the docket today. We have on the first case, Gordon Lightfoot versus, I'm not sure what this says, Public Supermarkets, I'm sorry. Is the appellant ready to proceed? Yes. You may.
May it please the court, counsel, I'd like to reserve 9 minutes of my time for rebuttal. This is a summary judgment case. There are a lot of interesting issues in this case. One of them is the summary judgment rule and what is the burden of the movement in a summary judgment case. There's also issues about the fact that the trial court, when deciding this case, had been presented with an opinion by a federal district court judge, Judge Hinkle, and she reached the conclusion that that case controlled how this case should be decided, and both parties gave contradiction versions of what a video showed, what the video evidence in the case showed, and the court ruled without looking at the video, and that is an issue that is also important in this case. The complaint is on page 7 of the record on appeal. And the complaint, if you look at it, raises several issues, several ways in which Mr. Gordon Lightfoot, who's here in the courtroom, right there, how he could have prevailed against public supermarkets. It wasn't simply a case of the statute 768 or 755, the transitory foreign substances statute. That was the only basis of a liability alleged in the complaint. Publix filed a motion for summary judgment very, very early in the case, and it argued that they took the deposition of the plaintiff, they served them interrogatories, and he filed responses, and they focused on the fact that Mr. Lightfoot didn't know how the substance that caused him to fall in the supermarket got there, how long it had been there, whether anyone else had seen it before.
Can I ask you, counsel, you mentioned the statute. Does that statute not apply to every slip and fall on a transitory substance in a business?
It does, but it does not apply exclusively. The statute itself has a provision, the subsection 2, which says, this section does not affect any common law duty of care owed by a person or entity in possession or control of a business premises. So I think that we have a situation where a statute specifically alleges situations where the basis, at least one of the bases by which the plaintiff is suing has to do with a substance on the floor that, for example, caused a slip. So if that is at least in part one of the bases under which the plaintiff is pursuing the case, then the statute obviously is triggered, becomes relevant, and it will address the whole question about how the plaintiff can prove actual or constructive possession, what are the burdens of the plaintiff, what does the plaintiff have to prove. So there are other ways that a plaintiff can sue a defendant like Publix here and allege liability, even if it was a slip and fall where there was a substance on the floor.
And one of the allegations, as I understand it, was a negligent mode of operation, right?
That's right.
But there wasn't a ruling on that, but there wasn't a motion for rehearing saying, hey, Judge, you need to rule on that.
That is correct.
So was that, and I know you weren't trial counsel, you made that abundantly clear in your reply brief.
Yes.
But is that not fatal to at least that claim?
I don't think that the defendant, that Publix argued that it should be fatal. Maybe it did. I don't recall addressing that issue in the reply brief. Certainly, that was an option available to Morgan & Morgan. They could have filed a motion for rehearing and bring it out to the trial court's attention that there was a problem. This case has so many problems with the fact that a few months after the summary judgment was entered, just within a few weeks maybe, Morgan & Morgan hired one of the attorneys who were representing Publix, and then Morgan & Morgan stayed on this appeal and even let the initial brief become late. So they could have, for example, moved for a hearing, they didn't. They could have gone to the trial court and, for example, argued that Publix's counsel actually lied, openly lied to the trial court, saying that there was no one present, that there was no one shown on the video that is associated with Publix that could have seen the spill, and the video shows otherwise. And they didn't do that, and they stayed on the case even though there was a conflict of interest.
But as far as this case is concerned, though, I mean, maybe there's professional liability, maybe there's bar concerns, but we just deal with what's in front of us, right? I mean, I'm not aware of any exception. I mean, you talk about fundamental error in the reply brief, but, you know, I'm not saying that there's malpractice, but had there been malpractice, that's not fundamental error, right?
No, malpractice is not fundamental error. The fundamental error is more based on the fact, a combination of facts, that I think that there was clear and unequivocal intent by Publix to not have the trial court see the video. And once you see the video, you know why, because it shows something that would be hurtful to Publix. So they filed an affidavit that is completely vague. They actually make several times in the summary judgment hearing, several times they make specific statements about the content of the video. The attorney for, and again, it wasn't the same appellate counsel as well, it's different trial counsel. But they make very specific, in open court, statements to the trial court that are false. They say plaintiff will argue that Publix employees were either in the vicinity or walked by and did not see the liquid or otherwise had an opportunity to see the liquid on the floor. This is on the transcript. It was a supplemental record. So using the transcript page numbers, on page 12 and 13 on the top, there are representations by counsel from Publix that are false. Then on page 14, he says, in other words, Your Honor, there was a complete absence of factual support for the idea that anyone that was employed by Publix during the 7 minute and 8 seconds time period was in the area or had an opportunity to view the substance of the floor prior to the fall. The reason why I raised, and there's another one, that's on page 14, and there's another one again on page 37 of the transcript. The reason why I believe fundamental error could be considered is because obviously it's a very narrow situation. You don't want to have every single time someone argue you should consider something that the trial court did not consider. But here we're talking about a situation where there was, in my opinion, a fraud upon the court. Then you have a situation where there's Mr. Lightfoot is being represented by somebody who is conflicted out and they do not withdraw, they do not timely file a motion with the trial court to revisit this whole issue, the whole issue that the mode of operation allegations were not addressed. There are significant concerns that I think affect the trustworthiness of the public on the justice system. If
Counsel, what is it that you are asking us to do? Are you asking us to, kind of independently look at this video, kind of make a determination of whether we think that maybe we agree that it's inconsistent with the order? That doesn't sound like something real familiar to appellate judges. We have a summary judgment order. We have an appealing that order, claiming that it is inconsistent with the law, inconsistent with the statutes. Sure. That's what we're here for. We're not here to determine whether or not there was a fraud on the court below, are we?
No, you're not. Well, I think that when you look at fundamental error, you kind of look at the fairness of the proceedings. And it is interesting that the Florida Supreme Court found that video evidence is so powerful that it changed the entire summary judgment rule based on a case where the whole issue was video evidence that contradicted the testimony of other witnesses. And here you have a situation where the court could have in its possession a video that is referenced by both parties at the summary judgment hearing. They show some photos from it. They discuss it. They found an affidavit that actually purports to describe the video. But I come into the case later, right? I take over from Morgan & Morgan after the initial brief is due, and I watch the video and I say, oh my gosh, this video shows that the trial court's reasoning here was that if anybody related to Publix was in the vicinity, she would rule in favor of the plaintiff. So I see that on the video, and I'm like, okay, what am I going to do? The video clearly shows that he should have won, that there shouldn't have been a summary judgment in this case.
Are you saying there's somebody else besides Mr. Gordon, the off-duty Publix employee who
No,
was there?
there is record evidence. There's record evidence that was filed by the Morgan & Morgan attorneys, the deposition of the main manager for the store. And he indicated that that was where they were doing inventory. And I'm not sure if y'all have been to Publix, but you see sometimes the different workers with the machine, they're going through the aisles, they're counting how many products are for a particular, so they're walking around. The video on this case, which I thought should have led to a concession by the appellee. The video in this case clearly shows employees of a different company that works for Publix in uniform, carrying ladders, walking by the spill in the 7 minutes period. Several times you see employees there. There's one, I think, even working down the aisle. They come really close, and actually just a few seconds before Mr. Lightfoot comes back and slips and falls, one of those workers walks right by the spill. So I'm in a situation where I see the video and I see, well, the trial judge would have ruled in his favor, and yet we're going to let.
So the trial judge would have ruled in your client's favor if she had seen the video, but
Yeah.
she didn't, so she didn't rule in his favor. So I don't know what we're to make of that.
Well, the first thing-
The issue here is whether there is evidence to show that Publix had actual or constructive knowledge of substance. The order talks about that, the briefs talk about that, and I thought that's what we were here to talk about.
Well, we are here to talk about that, and actually the main issue in this case is not the video. The main issue in this case is the following, that when Publix filed a motion for summary judgment, they did it on very narrow issues about the statute. They didn't cover all the possible ways that you can recover under the statute on their motion. They left open questions that, based on the allegations in the complaint, the plaintiff could still prevail at trial. They only addressed a very narrow question on whether there was actual notice with respect to a person who he caused the spill, but he says, I didn't see that I caused the spill, right? So they addressed very narrow issues. They don't address all the issues that are discussed in the statute. For example, subsection 1 of the statute says constructive knowledge may be proven by circumstantial evidence showing that, and this is a may, not a shall, so there's other possible ways, I'm assuming, based on how constructive law has been interpreted over the years by the courts, but it says the dangerous condition existed for such a length of time that in the exercise of ordinary care, the business establishment should have known of the condition, or the condition occurred with regularity and was therefore foreseeable. We have evidence that was presented to the trial court, and even the affidavit from Publix indicates that this spill was caused by a container that was served by an on-duty employee of Publix who served this guy who was on lunch break but also worked for Publix on a container that basically could leak. And the off-duty employee was...
Counsel, you're in your rebuttal time. Feel free to use it if you like.
I'm going to use a couple of minutes more to finish this point, and then I'll reserve the rest.
Up to you.
So thank you, Judge. So the point is, there is evidence on the record, even Publix's own evidence, that demonstrates that this container that caused the leak, there's no dispute that this container caused the leak, that this was created by Publix, that they served this employee.
Is the fact that it was created, to me, actual knowledge is knowledge. It's not that it was created by someone, it's that they know of its existence. And I readily concede that an employee can be the person with knowledge.
Right.
Is there any evidence at all that the employee had knowledge that there was a spill on the floor?
The employee denied having knowledge. Obviously, that's whether a jury could believe him or not. He has some self-serving interest in saying that. But he denied that he knew that he had spilled the fluid. He did go to have his lunch just a few minutes later, and he seemed to not have any juicy food inside. All the juice had seemed to be gone. So I think that could have alerted him to the fact that he may have dropped some of that fluid on the floor while he was getting the drink. Obviously, he knew that he leaned forward, that he was holding the package in a careless manner. He knew that he had been served something that had fluids in it. He was carrying that around. I think that obviously the employee who served them at the deli didn't know that there was going to be a spill. But again, Publix with this case involving a situation where there's a potential for liability based on the fact that they created this hazard or that this happened regularly. So they didn't say, for example, that, oh no, these containers are spill-proof and this is not a regular occurrence when other customers buy our food. We have never had a situation where a fluid from this container spilled. They didn't do that. I mean, I'm saying that on a motion for summary judgment, you have some affirmative duty to either show that the plaintiff cannot establish a way to win a trial or disprove the facts, right? To show, well, here's what really happened, and under what really happened, the plaintiff cannot win. They failed to address many of the issues under which the plaintiff could have won in their motion itself. So that's the main argument, first of all. And I'll reserve the rest of the time for rebuttal. Thank you.
May it please the court, Jason Gonzalez with the Lawson Law Firm representing Publix Supermarkets. Your Honors, there were just two issues that were they attempted to preserve before the trial court, and the trial court, Judge Dempsey, was absolutely correct in her application of the law on each point and rejecting the arguments. But none of what we heard today or anything in their briefs relate to the two issues that they did argue at the trial court. None of these new issues were preserved. They've waived the other two issues, even though they had no legal merit. And those two issues are under 768-0755. They had an actual notice and a constructive notice argument. And the actual notice argument was based on the workers' comp law, and it has even been acknowledged in appellant's briefing that was an incorrect legal argument by trial counsel for the plaintiff. The workers' comp law doesn't apply. The Sussman case that was argued in the summary judgment hearing explicitly described that does not apply, and this off-duty worker is not the responsibility of Publix. Even if we were to stipulate that he did cause the spill, the record was clear that he did not. There was nothing in the record to suggest that he knew he had caused it when he leaned down for 13 seconds. But the issue wasn't preserved, and they don't even argue it here, and they acknowledge that one was wrong. On the constructive notice argument.
The constructive counsel, there is case law that suggests that actual knowledge applies if the company employee knew of the spill or created it. I don't think that there seems to be a lot of dispute, certainly that it could go to the jury that it was created by an employee. Does that demonstrate actual knowledge?
Your Honor, in your question to appellant's counsel was getting right to the point in the holding in the Whitlow case. That's exactly what that issue was. It says in Whitlow the fact that the TMH workers got on the elevator and there was something leaking from whatever they were pushing, that alone was not sufficient. That was all that was in the record. There was nothing in the record to show that those workers knew that they had caused the spill. And that's exactly what the court said in Whitlow. Whitlow still needed to show that TMH employees knew that the stretcher was dripping. This she failed to do, and that's why. So you're exactly right. They could have shown that if there was record evidence. However, if there was record evidence that Mr. Gordon knew that he caused the dangerous condition, which there isn't, his testimony was clear, but that also doesn't work for them. Even if he said that, he was off duty. So Publix is not responsible for him in that context. This isn't a workers' comp case. So they would lose either way on that point. Then you get to their constructive knowledge argument before the trial court. That was the gap in time argument, the 7 minutes, 8 seconds from the time the assistant store manager, Mr. Heron, walked through, observed that the floors were clear. 7 minutes, 8 seconds later is when the allegedly Mr. Gordon spilled without knowledge that he had
Is
spilled.
there any case law saying how much time is a sufficient length of time for there to be actual knowledge? I mean, clearly, if it had been there for an hour, you would concede that that's at the front desk. That's probably enough, right?
Yeah.
But if it's there for 30 seconds, that's probably not enough. So where in between that range is a sufficient length of time?
I don't know that there's a case that puts a bright line on it. It may be different for different types of businesses, but the Straub versus Moran Foods case is the one that, in this instance, clearly 7 minutes, 8 seconds doesn't work. In Straub, it was something around 8 minutes, but they have parenthetical citation to a number of cases where this has been considered. The first one they mentioned, the Montgomery case, Montgomery was less than 15 minutes, around 15 minutes was not a sufficient amount of time. They've got another one that's got 3 minutes, was not sufficient, 4 minutes, not sufficient, 5 minutes. These are all cases in the parenthetical cite in Straub.
You know, certainly, let's just take Publix, you know, if it were in a dark corner of the store where there's hardly ever any customers, that the amount of time that is sufficient is going to be significantly longer than right at the front, right at the cash registers, which is my understanding of where the spill occurred here. So I understand your point. I did the same thing, just to kind of look to see whether there were any cases that drew lines. But isn't that line really going to be dependent on the facts of the case?
I think it may be dependent on the facts of the case, and the statute didn't draw a bright line. Certainly, a ruling that 7 minutes was enough time to put, constructive knowledge on Publix, that would be so extreme that I can't imagine a court could ever come to that conclusion, because that would place a duty on that every floor in every supermarket in the state of Florida must be inspected every 7 minutes, or the supermarket is negligent under 768-0755. So that couldn't be the rule. And these cases have said, I think they're similar retail stores. The Montgomery case, where they said 15 minutes would not be a sufficient amount of time to appear. That was the Florida Jitney Jungle store. So every Publix floor needing to be inspected every 7 minutes, that can't possibly be a proper application of the statute.
Is it appropriate for the courts to decide that as a matter of law, or is that a fact question that, I guess conceivably could be overcome on summary judgment? I mean, is it a jury question? Who decides that?
I think it could potentially be a fact question. Here, they never again brought it up on appeal. So it's been waived in this case. Maybe in another case there could be a determination of whether or not it's just going to be a factual determination. But it can't, and it also just can't possibly be.
Isn't the standard, as I understand it, from the federal summary judgment rule, whether a rational fact finder could determine that 7 minutes was sufficient to put a business on notice, and no rational fact finder could do that? I mean, summary judgment, I think all practitioners know in the personal injury world, up until the time it was changed in Florida, was granted far more often in federal court. And I think part of the reason is federal judges had the authority to determine, no rational fact finder could determine that. So I think my colleague's question is well stated. In other words, is that the standard that a judge should apply on summary judgment, whether a rational fact finder could determine that 7 minutes, 3 minutes, 2 minutes, 5 minutes? Is that how it works?
I think that may be the case if they had preserved the issue.
Yeah, I understand that.
Yeah.
I'm talking hypothetically,
Right.
academically.
Right, and again, under the new standard, it's not our job to disprove every element of the case, but if we show that there's just not sufficient evidence, and so, yes, Your Honor, it's a much, the standard is lower, of course, under the federal
But
summary
my
judgment.
question is, does the judge look at this and decide, assuming it was preserved and we were addressing it, all right, no rational fact finder could reach a verdict based on a substance being on the floor for 7 minutes, 9 minutes, 12 minutes. Is that within the purview of the trial judge? Under the summary judgment rule?
Under the rule, well, and under the precedent that Judge Dempsey looked at, I think that would be correct. But again, not preserved here. And then the inventory workers argument that just came up again, that was never raised in the trial court. In fact, on page 18 of the appellant's brief, they say plaintiff's trial counsel does not mention the inventory workers. The inventory workers, I think, is an actual matter of what was in the, if you just look at the affidavits that were actually in the record, there's nothing in the record to demonstrate they were in close proximity to where this happened. But in any event, once more, it's an issue that comes up and is argued here on appeal for the first time. It was not, they even concede it was not raised before the trial court. So the two issues they did talk about on summary judgment weren't raised, and Judge Bilbrey earlier in questioning appellant's counsel got right to the point on some of these things that they point to that they may be trying to claim are errors that first appear in the actual summary judgment order by Judge Dempsey. The case law has been very clear, from Judge Thomas's opinion in the Pensacola Pier versus King case, that would have to be raised in a motion for rehearing. You have to give the trial judge an opportunity to correct that if you think here's an error that appeared first.
I think your learned opponent agrees that should have occurred.
I think that's probably right. I think that's all we have. Thank you, Your Honor.
A few issues to address in rebuttal. First of all, I think that the movement in the case was public, and the movement filed an affidavit in support of their motion for summary judgment very early in the case before many of the depositions that were done had taken place. They never amended the motion for summary judgment to clearly evaluate all of the evidence and then decide is this a case where summary judgment is appropriate, and then present a proper argument to the trial court. I think that the summary judgment rule is often misused, and a motion is filed just claiming that the plaintiff cannot prove a case, and the court should not allow such a practice to go forward because the rule is very specific on the requirements, and they totally fail to show under the facts of this case that were established by several depositions that they were entitled to judgment as a matter of law, that a rational juror could never have concluded that Mr. Lightfoot could present a case that was viable. Judge Hinkle addresses the whole issue of the timing. He says that the statute doesn't establish a grace period of 15 or 20 minutes or any other fixed length. He says that a jury could find that if the liquid was on the floor for long enough for a passing employee to see it, then the liquid was there long enough for the employee to that in the exercise of reasonable care to know that it was there. And had an employee not passed by the spill, in that case, he says that summary judgment would have been appropriate. So in that case, it was only 2 minutes, and I understand that if there was no additional evidence that someone could have seen it, they would have lost with its 2 minutes. But I agree with Judge Winokur that you have to look at the entire circumstances of the case to see whether a reasonable juror could rule in favor of the plaintiff. And I think that the whole question of constructive notice has to do with analyzing the facts and analyzing whether a reasonable jury could conclude that public should have known that there was a spill in place. The way that the Publix, if you look at the affidavit that Publix filed in support of the motion for summary judgment, it is a very, very weak affidavit that doesn't really cover all the details that would be necessary for the trial court to make a conclusion as a matter of law that Publix should win. They talk about, in the affidavit, they talk about Publix associates. I think that although I conceded in the briefs that Morgan & Morgan never specifically brought up, oh yeah, there were this inventory workers there, but I think that if you look at the argument, I think that this young attorney for Morgan & Morgan was just talking about Publix employees and maybe didn't think in his mind, okay, these guys are working for the inventory company that is separate. I found that in the record later, so I want to be open and upfront to the court and explain who these people are. But the fact is that at the summary judgment hearing, the attorney for Mr. Lightfoot did argue that there were employees of Publix that walked by the spill in the 7 minutes and 8 seconds. And so under the holding of Judge Hinkle, that's why I say that, the trial court would have ruled in favor of the plaintiff, of Mr. Lightfoot, had she known that those employees really had passed by the spill. But several times in the hearing, the attorney for Publix, not Mr. Gonzalez, the underlying attorney for Publix, argued vociferously that there's nothing in the video showing that such employees were there. Obviously, I wish that Morgan & Morgan had filed the video. But there is argument, I think, preserving that issue. Even though they don't mention the inventory workers, I think that it was Publix's own duty, knowing that this was an inventory day, knowing that there were inventory workers all over the store that day, and there's case law that says that constructive knowledge can come from an agent, not just from an employee, but an agent, right? And I did cite a specific case that talks about a store, a retail store, where there was somebody working on bringing flowers, maybe maintaining the flowers. It was an independent company.
Counsel, your time's almost concluded.
All right, well, I'm going to obviously rely on the briefs about Whitlow. The rehearing is still pending on that case. In that case, there was a concession that it was an actual notice.
You may briefly conclude.
Thank you. Well, that's all, Your Honors. I mean, I understand that there are issues with how Morgan & Morgan handled this case, but I do believe that the briefs raise a sufficient basis for reversal for summary judgment on the issues that were preserved. Thank you very much.
The next case we'll hear on the docket is Burns v. State. Is the appellant ready to proceed?
Yes, Your Honor.
You may.
Good afternoon. May it please the Court. Michael Hoffman on behalf of the appellant, Mr. Burns. I'd like to reserve 5 minutes of my time for rebuttal. I'm intending to focus my time this afternoon on the first issue raised in the briefs, and I'll address any questions that the Court has regarding the remaining two issues. The first issue, I think, is a pretty straightforward issue dealing with relevancy. And when is a matter relevant? If there's limited relevancy, when is the issue or the evidence overly prejudicial such that it outweighs any probative value? And then ultimately, if the court agrees that it was error in this case, was the error harmless? Has the state met its burden of proving that it's harmless? The evidence in question in this case concerns a baby being covered in blood. This is a case of self-defense. My client was charged with murder for his girlfriend at the time, who had an 8-month-old baby in the house. There was no eyewitness. My client's testimony was that he came home late. The alleged victim was upset that he came home late. My client said that she attacked him. He defended himself with a knife. Ultimately, she died from several stab wounds from that knife that, again, according to my client's testimony, they were struggling over. After the incident, my client left. The baby was present at the house at the time. The baby could not crawl, could roll. My client said that the baby was on the bed in the bedroom during the incident, and after the incident, he put the baby on the floor and then left. So before trial, defense counsel said, Your Honor, we've worked out most issues, but the one issue we're still haven't been able to agree upon is I don't think the state should be able to introduce any evidence about when law enforcement officials arrived, the baby was next to the mother covered in blood. And then there was some back and forth discussion where the state said, well, we need to be able to at least establish why it was when law enforcement arrived roughly an hour and a half after the incident, why they came inside. They heard a baby crying out loud, and that was their reason for going inside. And defense counsel conceded that, yeah, I think that's relevant, so I'll agree that that should come in. But at the very least, anything about the baby being covered in blood should not come in. And the judge clarified, you're not going to introduce any pictures of the baby in blood. The state said no. But the judge says, okay, I'll allow the deputy to testify or the sergeant to testify that when he arrived, the baby was covered in blood. And this occurs on page 333 of the record, or the trial transcripts, I'm sorry. The question from the prosecutor, this is to the Sergeant Thigpen, describe what you saw. When we came into the kitchen, it just looked like a normal kitchen, walked into the living room, and as I come around the corner, following the sound of the baby crying, you could see him sitting on the floor covered in blood. And as we walked into the room, there was a female lying there in a pool of blood. It goes on to say, just to add a little more context, question, all right, whenever you see him, or whenever you say him, are you talking about the baby? Answer, the baby, yes, sir. Question, okay, was there anybody else in the house besides the baby and the deceased female? Answer, no. Question, all right, what did you do next? Answer, once I got to the bedroom, Mike, who is Deputy Mike Vickers, comes right in behind me. He said a couple of words, cuss words, like, you want me to say them exactly? Prosecutor, no, that's all right. Sergeant Thigpen, okay, so he picked up the baby, went outside, and called for EMS. So a little more context. We don't know what those cuss words are describing. Is it describing the dead body? Is it describing the baby being covered in blood? I mentioned, or I've explained in my brief, that we know that there was at least one reaction to what was seen by law enforcement officials when they arrived, because one of the jurors' wife was on the EMS crew, and that juror was discussing in chambers about whether or not that juror had any knowledge about this case, and that juror said, did your wife talk to you about the call that she had received? And the prospective juror who did not serve on this jury. Just briefly, she had some issues, that's all. The prosecutor, I'm sorry, if you don't mind asking, she had some issues? Juror, yeah, she just described to me in reference to a baby that was covered in blood that she had to hold. So clearly, before this occurred, before the argument was even made, we know that this is, Taylor County, it's a small county, but there's at least one juror who had a connection to EMS and law enforcement who had responded to the scene and already said, I had some issues because the baby was covered in blood.
Can I ask you, counsel, you mentioned no photographs. You would concede that this didn't become a central feature of the trial, right? So the more probative than prejudicial assessment, that's a abuse of discretion standard,
yes,
right? So how do those cases where there's bloody autopsy photographs and, the prosecution's really hammering this extraneous stuff, how does that apply here when we've got apparently just one mention of it and no photos?
So you talked about more probative. I would maybe say that perhaps falls into the last category I was discussing, which is harmless error. Because I still think there has to be the initial discussion for the first two pots that I was talking about. Is it even relevant? And if there's any relevance, does the probative impact outweigh, does the prejudicial impact outweigh that probative value? The judge makes that decision pre-trial. As far as what happened from that point forward, I agree with you, Your Honor. This was not mentioned in closing. So from a harmless error standpoint, that the cases that, and I think the parties below said, and we haven't found any obviously on appeal, there's no case dealing with this exact issue. I didn't look to the cases that actually had photographs, and some of those cases do involve perhaps the issue being mentioned by the prosecutor in closing, and that goes to is the issue harmless. If I could come back to whether it's harmless, I still want to talk about it's simply not relevant. The baby being covered in blood is not relevant to any issue in this case.
Is that issue preserved? Did defense counsel make a specific argument that it was irrelevant? My
Yes.
understanding is that it was, primarily a 403 argument, which is not an argument that it's irrelevant.
No, well, no. If you look at page after the prosecutor made the argument as to why there may be some relevance. This is page 298, Mr. Prince. Just briefly, Your Honor, he goes on to say, the state is not bound to accept the defense stipulation. That doesn't mean the defendant acknowledging certain facts. If it was going to be disputed that the killing took place at 2 a.m. versus 4 a.m., if that was disputed, then that evidence would have a higher probative value. I'm telling the court that's not a dispute. And he goes through and mentions each of the things that the prosecutor referenced as to why this could be relevant.
Well, why is it not relevant? What is your argument there precisely?
So let's look at the definition of relevancy. Evidence tending to prove or disprove a material fact. This baby being covered in blood is...
Well, I understand that, but when you're talking about a trial over an issue of self-defense, the fact that there's a baby in the house and the baby is, let's separate the covered in blood aspect for a second. Would you agree that the fact that the deputy saw a baby there would be relevant?
Yes, and I will, not to shortchange you, but
Sure.
The covered in blood is the issue.
Right, okay.
Sole issue I'm arguing.
Okay.
The baby being there is relevant in every other way. I acknowledge that. The baby being on the bed is relevant. The baby being placed on the floor, that's relevant. I don't dispute that. Certainly the state can point to, and so I'm saying, even just a little bit of relevancy, I'll concede. The baby being in the bed where my client is saying this occurred, of course the state's going to be able to say I'm not sure that's true, or maybe it started in some other room, or do we really
But
believe?
does being covered in blood go to premeditation?
The baby being covered in blood
Right.
go to premeditation.
In other words, isn't the argument or the allegation that he put the baby on the floor by the mother, the deceased woman? Is that part of the state's case?
I don't believe so.
Well, so tell us what occurred in terms of what your client said about the baby, and doesn't it go to the context of how'd the baby get on the floor covered in blood?
I don't know that we know how the baby got covered in blood. I
I
think.
assume by being next to the deceased woman, right?
Right. So again, we know the baby couldn't crawl. The baby could roll. My
But
client.
doesn't it go to his state of mind that, again, this is just a question, it's not an accusation. But does it go to the state of mind or of why he didn't try to help the child? I mean, isn't that fair for the jury to know? He's arguing self-defense. She tried to attack me, understand that's his testimony, and the jury certainly could consider that. But can't the state argue, well, then why did you leave the child there?
Well,
Covered in blood. I mean,
so again, we don't know that the baby was covered in blood when my client left the baby there. When I've read these facts, and I've never considered it any other way, I believe that my client was concerned about the baby's well-being, which is why he took the baby from the bed and put him on the floor, because falling off the bed would be dangerous to the baby.
Right.
So there's an assertion by the state when this is being argued that, he didn't care for the baby. I mean, he fled, and I'm not spending much time on my second issue because I acknowledge the fleeing is consciousness of guilt, or at least the state can argue that. So him fleeing, but when he came back, the first thing he asked, and that came in during the testimony is the baby okay? But he's not charged with child neglect. He's not charged with anything relating to this baby. The baby is unharmed. So the fact that the baby is covered in blood, I don't think is relevant to premeditation. I don't see it. I don't think it's relevant to any issue.
The argument was he placed the baby on the floor next to the mother, right?
I think he placed the baby on the floor. So as far as the state
But
wanting...
does that not go to the idea that your state of mind is such that you have no concern for the child whatsoever, other than, okay, yes, I put him on the floor to make sure he didn't fall, but that doesn't really go with a kind of self-defense claim, does it? In other words, would a commonsensical view of a self-defense claim be, I'm calling the police, I just had to defend myself against my ex-wife, I've got the baby here, I want to make sure the baby's okay, rather than I just show up at the police station and say, hey, is the baby all right? I'm asking.
It was at his house, but no, you're bleeding into the second issue, and which is why I was. Yes, I understand those are concerns that would potentially the state can point to as being contrary to self-defense or allow get over potentially a JOA issue. But as far as again, I guess the way I'd answer the question is this. If the baby being covered in blood was relevant to any of the issues the state was trying to prove, then going back to whether it became a feature of the trial, you would have expected the state at some point to make that argument to the jury. And you see, to properly establish that either premeditation or whatever it might be relevant to, that's why the baby being covered in blood is relevant. The baby being covered in blood wasn't mentioned a single time other than the deputy talking about seeing the baby in blood and then what the other deputy's reaction was to it. So I don't think the prosecutor thought it was relevant to anything because the prosecutor certainly didn't make that point to the jury throughout the trial. I think the idea was, especially when you've just heard in jury selection, that one of the jurors' wives had this reaction to this case, and what the reaction was not her being the alleged victim being covered in blood, it was the baby being covered in blood. So now I really want to get that point in front of the jury, just for whatever impact it might have. And that would be improper. Because
I know we're well into your rebuttal time, but can I just ask you briefly about your second issue?
Of course.
And I'm going to grant him another 3 minutes.
Thank you, Judge.
The other side.
I appreciate that. The excessive self-defense, would you agree that at some point, if there's enough excessive self-defense, it could become premeditation? So if somebody, I've got a bat, some kid comes at me, and I hit him one time with the bat. Okay, maybe that's excessive self-defense. He's lying on the ground and I hit him 20 times with a bat. At some point, maybe I'm premeditation, I have premeditation, a time to reflect, a time to stop, and I don't, so then it's conceivably murder if I kill the kid, right?
It can be. I think that there'd be, I think from a legal defense standpoint, if that's the type of reaction you're having, perhaps you're now going into the territory of some type of heat of passion that you've lost control in your response. But I also acknowledge that's not going to be an issue for JOA. That's going to be an issue that can be argued to the jury.
Right. So, intent and the timing, we've said, the premeditation can be formed in just mere seconds, pull a trigger, and that's premeditation conceivably, or that's enough for a jury to find premeditation. So, isn't it the same thing?
JOA issues are very tough.
Here, basically. Thank you.
I acknowledge that the difficulties with the JOA claim because of the potential animosity between these two that existed from evidence that the state presented pretrial, from the fact that he fled, which the state can utilize as consciousness of guilt, and from the fact of the snitch statements that came in. Of course, my client denies those statements having been made, but nevertheless, that's evidence that came in that the judge had to look at in the light most favorable to the state. So,
I appreciate your candor.
Okay. Thank you. I'll reserve the rest of my time for rebuttal.
My name is Darren Snoopy. I represent the state of Florida in this matter. There's 18 minutes on there. Do we have 18?
I gave you an additional 3 minutes. You're not required to use it, but you have it in case you prefer to use it.
Thank you very much. I'm going to start with, when you kill somebody, and it happens, and you decide to use a 5 to 7 inch knife blade to do so, and you stab that person cut them up to 8 different times, one of those being a slicing of the throat and the others being stab wounds to the head, various parts of the head, the neck, the upper torso, all evidence of a conscious intent to kill, which supports premeditated murder, you probably shouldn't be surprised that there's going to be a lot of blood. So I'm a little bit, as I indicated in the answer brief, surprised at the claim that if the defendant admits to putting the baby on the floor after having killed that baby's mother, with the baby being only 8 months old, and then leaving the baby there, going off to stick his truck in a ditch somewhere and then run off into the woods with the murder weapon, why would he be surprised that there's going to be blood all over the baby? Who's able to roll over but not walk, not crawl? So it would offend the intelligence of a group of jurors, in this case, to think that, well, you left the baby behind, and wasn't it just amazing that the baby didn't get a drop of blood on him, excuse me.
What's the state's argument that I mean, certainly the baby is relevant. I think that's conceded. And the position of the baby and, the officers here and the baby coming in. What's the state's argument that the baby found with blood on him is relevant?
Well, first of all, let me flip to the end of that, and then I'll come back to answer it. The argument made below, and the argument that this defendant is stuck with on appeal, is that this was as the trial counsel said, a straight 403 analysis. Well, that's important for this court's consideration, because a straight 403 analysis means I've conceded that the evidence is relevant. What I'm arguing is that the relevant evidence is substantially outweighed by the concern of undue danger. So that's where they are.
And I think Judge Winokur was getting into that with your opponent. Is there a relevancy objection first before we even get into the more prejudicial than probative analysis? Or are you saying there wasn't a relevancy objection preserved?
That's not preserved, number one. I want to make sure you understand that. And as we put in the brief, what's relevant about the baby being covered in blood is that the medical examiner's testimony in this case was that the baby's mother died by blood loss. The baby, having been placed next to the mother, supports and corroborates the fact that the mother died as a result of blood loss, and she died within less than, according to the medical examiner's testimony, in less than 15 minutes. So the baby being covered in blood, having been placed next to the mother, verifies, supports, corroborates, whatever words you want to use, the fact that the mother bled out. That's how she died. Because one of the stab wounds cut the carotid artery in half, separate and apart from all the other damage that was done. So it is relevant to prove how the mother died, which was by blood loss. That's number one. But number two, that's not the preserved argument. And 403 says relevant evidence, that's what we're talking about. If we've established that it's relevant, they didn't argue below that it wasn't, because they said, quote, straight 403 analysis, those are the words of the defense counsel, is inadmissible if its probative value is substantially outweighed by the danger of unfair prejudice. So the burden on the defense below and on appeal is to didn't convince the trial court, nor should they be able to convince you that the probative value was substantially outweighed by the danger of unfair prejudice. Once again, go back to what I said at the beginning. He stabbed her. By my count, according to the testimony, 7 times, plus he cut her throat with what was described as a gaping wound. So we shouldn't be surprised if her cause of death is she bled out in less than 15 minutes, which is a short period of time. But given the damage he did to her, perhaps we shouldn't be surprised that anything placed next to the mother, put a blanket there next to her, put a dog next to her that doesn't move, they're all going to be covered in blood because the floor was covered in blood. The mom is covered in blood. That's what happens when you do that kind of damage with a knife, 5 to 7 inches. So they've got to convince you at this level that the probative value was substantially outweighed by unfair prejudice. They can't do that. So we got Deputy Thigpen comes in, testifies to what he testifies. He's following the cry of the baby. The alarm goes off at 4:28, I guess, according to the Safe Touch records. So they respond. They're there in about 10 minutes. They're hearing the cry of the baby. They make their way into the house. As I recall, I think the door was open. Find the baby, pick the baby up and next to the mom, and like I say, why would we be surprised that the baby would be covered in blood? But once again, he's a murderer. We shouldn't be surprised, nor should we give them some sort of insulation that if you cut up the mom like he did, you don't get to just stick your head in the sand and say, you know what? We don't even like the facts of this case, but we don't want the fact that, we left the baby behind. He didn't get charged with that. It's not a criminal offense that he got charged with. But the fact is he left the baby behind. He left a non-testifying witness behind, and the witness was covered in blood. So how is that not relevant? And you know what? As a murderer, you get stuck with what you do. He's stuck with it. Nothing he can do about it. The law supports that, and there's no case that says he doesn't get the benefit of it. I think the one case that was cited by the defense in this instance on appeal relates to someone who was killed, as I recall, by being shot in the back. But what was introduced into evidence at trial was, I think, an autopsy photo of perhaps the head. And that's a case, by the way, from 1990. So we're going back, 30 plus years? That says, under those circumstances, you could have handled it a little bit different. But once again, we shouldn't be giving props and giving benefit and credit to someone who sliced and diced a mom and left behind her 8-month-old baby in the pool of blood. So in talking about the second claim, let me remind the court that there was testimony at trial as it relates to first-degree murder, that the aggravating bitch got what she deserved. And he said that more than one time to the person who came into court and testified, who was serving a prison sentence at the time. The aggravating bitch got what she deserved. Could we have any better evidence that he had a conscious intent to kill than the aggravating bitch got what she deserved? There were no defensive wounds on her. All the wounds were mid-chest and up, according to the medical examiner. And importantly, remember the context of this case and the arguments that were made below, which was the defense counsel tells the jury this was an immoral killing. It shouldn't have happened. The stand your ground law is a bad law. I'm a defense lawyer. I use it all the time. It's a horrible law. This was an immoral killing that he's got to live with. Well, yeah, he's got to live with it, but he ought to be living with it for the rest of his life in prison based upon what he did to a defenseless woman. And according to testimony at trial, when he returns 36 hours after he's done the deed, he's asked, do you have any injuries? He says no. So when you add all that up and you put it together and you give a package to the jury, what have you given them? You've given them somebody who was mad, who was frustrated, who didn't deal well with the fact that he got to his house late and she's waiting for him because he'd been out at a bonfire. Probably reasonable inferences, they get into some sort of argument, and you know what? He loses it, gets a hold of the knife, takes the 5 to 7 inch blade, plunges it into her at least 7 times, and at least another time, then slices her throat wide open. Has the presence of mind, however, under those circumstances, to take the 8-month-old baby, it's not his, by the way, place it on the floor next to his mom, and then gets out of Dodge. which is consciousness of guilt. He exactly knew what he was doing. He can stick his head in sand now. He can testify all he wants, which is what he did. I don't know what I did. I don't remember the details of that. Well, it's funny. You know what? You remember the details beforehand, and you remember the details afterwards. It's a remarkable coincidence, don't you think, that you don't remember the actual part where you sliced and diced her. Wow. But the jury didn't buy it. The argument below was he was justified. Defense counsel used this argument, justified in killing her. Acknowledging it, admitting to it. But he was legally allowed to do it according to defense counsel, and apparently the argument made on appeal. Well, the jury got to consider that. They're the finders of fact. Took them less than 3 hours to say, that was actually after a few questions that they asked as well. None of which, by the way, none of the questions, there was more than one question from the jury, none of the questions related to, let's talk about that baby covered in blood. Nothing. So there's the isolated reference at the very beginning of the trial. We got a trial transcript that's more than 750 pages, as I recall. There's an isolated reference to it. And somehow or another, that relevant evidence is supposed to substantially outweigh is outweighed by the danger of unfair prejudice. Doesn't fit very well. But in any event, the jury saw it for what it was in less than 3 hours and convicted him as charged of first-degree murder. I think I've covered everything that I can cover with you all today. We're asking the court to affirm the conviction, affirm the judgment and sentence we acknowledge in our brief. With respect to Claim 3, there are some issues with the costs that were imposed. We'll rely upon the brief for that, but there's no merit.
Well, so actually, I have a question for you about the cost issue.
Okay, yes.
And of course, appellant can respond in rebuttal. There's a concession that because there was no statutory authority given for some of the costs, that they should not be imposed. But my understanding of the rule is that the statute needs to be referred to, or an explanation in the record as to what those additional costs represent. So if there is a, explanation in the record as to what the additional costs represent, is that sufficient to affirm the sentencing order or the cost order?
I don't recall the specifics. Knowing how those things kind of work as a practical matter, it would seem that there should be some reference to that at the time of sentencing as opposed to something related afterwards.
But if it's at the time of sentencing, an explanation in the record as to what the costs are,
Then
without a statutory.
if there is an explanation, then I stand corrected with what I wrote. Okay? I will acknowledge that. Okay? Thank you.
Thank you.
May it please the court. I don't want to spend much time on that question, but I'm looking at page 644 of the record, and I don't see an explanation. So if you, Your Honor, seem to be referencing something that might be in the record that would be the explanation, and if there's an explanation that puts me as appellate counsel on notice for the basis for this charge, then that would be an issue.
When the court announced the $201 cost, had the transcript page, but I don't think I have it with me right now, but it was associated with the statute covering batteries and other crimes. In other words, there was certainly an indication, not certainly, but there appeared to be an indication in the transcript that was the purpose of the $201 fine, which just so happens to be exactly what the mandatory cost of Section 9.808, I believe, sorry if I got that wrong,
$151, I'll quote it, Your Honor. I'm on page 644.
No, not the $151.
I'm going to quote it, Your Honor.
Okay.
Quote, the $151 and 101 surcharges related to batteries and other violent crimes. I wouldn't know what that means, and I'm the one that raised this motion. So the whole idea is to put reasonably intelligent people on notice as to you would know that 151 and 101 surcharges related to batteries and other violent crimes, and the clerk said 201, excuse me, that makes it clear to anyone reading that what the statutory basis is for the imposition of that cost. I'm not aware of that, and that's the whole point of me filing my 3.800B motion. If the court would have taken the time to look at the motion and rule on it within the 60 days, maybe there would have been an issue there, but that didn't happen in this case. But this court's case law, the cases around the state say that you have to provide some type of statutory reference in order to allow the appellant and appellant's counsel to understand what the basis for that is. And I simply don't know what that is. I haven't memorized every one of the cost statutes, and I'm pretty familiar with them, probably more familiar with them than anyone in the entire state, because I look at these issues in every one of my cases. I wouldn't know what that means. So I don't think that supports that. Let me get back to this whole idea of this objection and whether it's preserved. I'm not sure it matters. I may be splitting hairs, but the case law talks about any minimal relevance is outweighed by the prejudicial impact. So yes, defense counsel below said it's 403. But we know that magic words aren't required to preserve issues for appeal. And again, it may not matter, because clearly he's saying the same thing. Any minimal, that's actually used in his quotes, any minimal relevance is outweighed by the prejudicial impact. But when the judge specifically says, and this is 293, it's your position there's no probative value, he responds by then saying no, essentially no, there's no dispute regarding those things. So I submit to you, no probative value is the equivalent of not relevant, but defense counsel is then backing that up by saying in any minimal relevance is outweighed by the prejudicial impact. And then one last thing, Mr. Shippey indicated that, if there was some argument that this baby didn't get a single drop of blood on it, of course, if defense counsel would have made that type of argument, then the state would have been allowed to reopen the case to point out if there'd been a pretrial ruling that, in fact, this baby did have blood on it. So that's not what was being argued by defense counsel in this case. So for that reason, I'd ask this court to reverse on claim 1. Thank you.
Thank you, Mr. Hoffman. Thank you both for your arguments. Court is at recess.
All rise.